So it is. We started recording, sir.
No issues, sir.
Yes, sir. Shall we start, sir?
Shall I go into the presentation, sir?
No, we'll start with the formal thing, sir.
Fine, fine.
Ronnie, you can proceed.
In a time of drastic change, it is the learners who inherit the future. The learned usually find themselves equipped to live in a world that no longer exists. Happy morning to one and all. A warm welcome to the galaxy of intellectuals. A warm welcome to the invited guest speaker, staff members, and dear students. Today is not just another day. It is a new opportunity and another chance for all of us to attend another webinar. Now, I request Dr. Kamakshi, Assistant Professor, to deliver the welcome address.
Good morning to one and all present here. It gives me immense pleasure to welcome you all on behalf of Dr. M.G.R. Educational and Research Institute, Faculty of Physiotherapy, to the webinar on identifying the intellectual property components at the early stage of innovation. At the outset, let me extend my heartfelt welcome to our Honorable Founder Chancellor, Dr. A.C. Shanmugam Sir, our Honorable President, Engineer A.C.S. Arun Kumar Sir, our Honorable Secretary, through A. Ravi Kumar Sir, who has kindly consented to conduct the program. I also welcome Vice Chancellor Dr. Geeta Lakshmi Ma'am for her constant support and guidance. I am delighted to welcome the most eminent speaker, Mr. D. Thiyagaraja Guptha, Sir, Deputy Director, IPR, Kolkata, to share his knowledge, and we are waiting to listen to you, Sir. I would like to extend my welcome to our Principal, Dr. C.V. Senthilnathan, Sir, for his constant encouragement and support. I also welcome our Vice Principal, Dr. R. Lakshmi Ma'am and Dr. Veena Ma'am, and all the participants and faculty members. Thank you.
Thank you, ma'am. Now I request Dr. Vaishnavi, Assistant Professor, to introduce our guest speaker.
A very good morning to one and all present here. I, on behalf of Faculty of Physiotherapy, take great pleasure in introducing our guest speaker, Mr. Thiyagaraja Guptha. He has completed M.Tech in Communication System from Pondicherry Engineering College. Mr. Thiyagaraja Gupta, sir, is currently working as Deputy Controller of Patents and Designs at Delhi, Chennai and Kolkata Patent Office, DPIIT, Ministry of Commerce and Industries, Government of India. He has been trained at Japanese Patent Office, Tokyo, in respect of the international treaties and Japanese National Office procedures. Mr. Thiyagaraja Gupta, sir, also holds the credit for his publications on patent procedures. Sir has conducted numerous awareness programs related to IPR for students, faculty members, entrepreneurs, and public sector organizations. Learning is a process that leads to change, which occurs as a result of experience and increase the potential of impact, performance, and future learning by Susan Ambrose. So I request all the participants to make use of this opportunity to gain more knowledge. Once again, I take this opportunity to welcome you for this session, sir.
Thank you.
Now over to Thiyagaraja Gupta,
Hello.
sir. Now over to Thiyagaraja Gupta, sir, for the.
Please.
Fine. Thank you, ma'am. So I think I can start with the presentation of identifying IP at the early stage of innovation. Thank you. I welcome all the participants of this webinar,
Yes, sir,
who have got interest in identifying their IP at the early stage of innovation. But to your surprise, we all have been introduced to IP, right, from our early childhood days itself. You'll be questioning me how. Most of you would have got the habit of writing a diary at the end of the day. Writing diary, the pages that you have written on the diary is one form of an IP. People are now taking photographs, selfies, from their cell phones itself, from their mobile phone cameras itself. All those photographs, all those selfies are one form of IPs. In the mornings, you could see women laying column in front of their houses. If the column is not a copied version, then that column is also one form of IP. And we all have got the habit of giving nicknames to our teachers at school days. Those nicknames are also one form of IP. You know, those nicknames are not any random names. Those nicknames will have some resemblance to either the character or the appearance of the particular teacher to whom it has been given. So every place, in every aspect, we have applied our intellect, our knowledge in coming out some sort of a creative work. All these creative works which you have been doing till date are all IPs. The only problem is that we do not know that this is an IP, and you have just moved on without giving due importance to it. But now my role is to show you where at other places are we missing out such IPs that you have created till date, and how are you going to identify it, take it to the next level of protection and to the third level of commercialization, so that such IPs are benefiting you as well as the society at large. This is what is the motive of my particular session today. This is what we are going to talk for the next 1.5 hours also. And hope my voice is loud and clear to all of you so that I could continue further.
Yes, sir. Very much audible, sir.
Fine.
You can proceed, sir.
Fine. Thank you. So before that, suppose if I am purchasing a piece of land, say 1,200 square feet of land, and I want to get it protected, what would I do? The first step I do is that I prepare the documents in a stamp paper, all those informations regarding the seller, the buyer, the land where it is situated, the adjacent land boundaries, all those stuff I put in a stamp paper, get it ready. Then I go to the sub-registrar office where this is being registered. Where I go there, I submit the papers, I pay the requisite fees, and later on, this land is getting registered on my name. This land is a property. It's a tangible property. Tangible properties are registered. Why should I register? This is my first question. Why should I register a piece of land on my name? Two aspects to it. One, to own ownership, to show ownership of the land, I need to register. This is the first part. The second part, if someone else is misusing my land, then in the court of law, I need to fight and get my rights recovered. For that aspect also, I need to register my land. Similarly, IPs or intellectual properties are also one form of property, but not a tangible property, it's an intangible property. Like a land that you have purchased is being registered under your name. Only after registration, you own rights on it. You have the rights to either build a house on the land, or to sell the land as such, or to give it on lease to someone else. So many rights we enjoy after you get it registered on your name. Similarly, IPs are also giving you a relative sort of rights, which you could enjoy only after registration. And I have been telling you IP till time. Before entering into my session, let me make it clear what an IP is. That is my first and foremost aspect. IP is nothing but intellectual property. One form of property similar to your land, similar to your two-wheelers, four-wheelers, similar to your buildings. Those are all tangible. This is intangible. These intangible properties are obtained by the application of your knowledge. To put it in simple example, I will tell you one case where it will be of more use to you. This happened some 10 to 15 years earlier when I was fresh out of college, and I had a friend who was studying in his first year, and he was a day scholar. You know, the problem with the day scholars is that they take the college bus to come to the college, but the problem is that the college bus never comes to their bus stop at the specified time. If it has to come by 8 o'clock, it would come by 8:15, 8:20, 8:30, God knows, depending upon the traffic, the bus comes to the bus stop. This is a perennial problem. This is not a one-day problem. It happens throughout the year. So this friend of mine asked me, "Arey Baba, you are an engineer now. Why don't you apply your engineering knowledge? And why don't you propose me a solution to this problem of mine? I come to the bus stop, I wait at the bus stop for almost 15, 20 or 30 minutes, and the valuable time is getting wasted for me every day morning. Why don't you find a solution for me?" It was a good problem posed to me, so I thought I should do something about it. When I thought about it, then I decided GPS was at its early nascent stage then. Why shouldn't I use this GPS in this scenario? So I went to the institution, spoke to the management, and I got permission to install a GPS locator tracker in the bus that is coming to that particular bus stop, and a corresponding transmitter. These things are placed on the bus. And alternative side, correspondingly, I need to have a receiver. Which receiver? I made use of a mobile phone. Android was also at its nascent stage at that time. So I needed to develop an app to coordinate with this transmitter, receiver, and GPS locators. Now this mobile phone with the app installed there, having a receiver to receive the locations transmitted by the transmitter of the bus, I was able to locate the real-time location of the bus. Now what did I have at my hand now? I had a property. This property is comprising of a system wherein a transmitter, a GPS tracker, locator in the bus, and a corresponding receiver on the mobile phone, and an app to integrate all these three hardware features. This is a system. This system is a property of mine. From where did this property come? Is it not by the application of my intellect? So a property that I obtained by the application of my intellect is called intellectual property. To put things that simple. So any work that you create by the application of intellect, and if that work is creative, is innovative, then we declare it to be as an IP, intellectual property. Fine, I think you will be now clear about what an IP is. With the assumption that you are clear about it, I'll move further.
Yes, sir. Very clear,
Yeah.
sir.
Right, I'll move further.
Yes, sir.
Sir, one more question now I got with you. Now I am purchasing a two-wheeler or a four-wheeler. Will I take this two-wheeler and four-wheeler to the same sub-registrar office? Absolutely not. I will take these two-wheelers, these vehicles to a transport office for getting it. Yes, for getting it registered under my name. So now I have got two tangible properties. One is the land, the other is the two-wheeler. Both needs to be protected, both needs to be registered, but there are two different offices for doing that. Similarly, in IP also, there are 8 different tools. If you go on to the next slide, yeah, here you could see there are 8 different tools, right from patents, trademarks, geographical indications, copyrights, industrial designs, trade secrets, layout, design of integrated circuit protection, and plant variety. So in an IP, there are 8 different tools. Like you go to sub-register office for protection of your land, like you go to the transport office for protecting your vehicles, IP for tangible properties there. For intangible properties, we have 8 different tools. But the difference between the tangible and intangible property protection is that for a land, there is only one office to get protected. You need not have any other tool to protect. But in the case of an intangible property, in some scenarios, just one tool will be sufficient to protect it completely. In some other scenarios, you need more than one tool to protect it completely. But for any innovations that is going to arise out of the engineering or science background, we predominantly focus on only 4 rights. One is the patents, second is industrial designs, third is trademarks, and fourth is the copyright. The other 4 rights, it's not that important at the nascent levels, but maybe at the later stages it might be of use. It might be of use to you. But initially, we suggest only these 4 rights: patents, designs, trademarks, and copyrights. So In this session, we are going to focus only on these 4 rights. The rest, the other 4 rights is not going to be covered in the session, maybe at the later stages. Now we'll go on from one after the other. We'll start with patents first. You could see what is shown there. Yeah, a simple basic model mobile phone. And you see there are 4 rights coming here for its complete protection. The working of the mobile phone, the conversion of your voice signal into electrical signal, then the encryption, then the transmission, encoding, decodings, all that is being done inside the mobile phone to convert our voice signal into an electrical signal and back to an electrical signal into a voice signal that is being performed by the chips inside the mobile phone is all innovations protected through patent. And if you could see this mobile phone, now see your appearance of the mobile phone. The keypads are placed 1, 2, 3, 4, 5, 6, 7, 8, 9, one after the other, in the 3 rows, 3 columns. But the one problem here is that if I want to type a message, say for example, if I want to type my name, I need first for typing Gupta, I need to press the numeral button 4. If by mistake I press that twice, G will not appear, it will become H. So I have to go back again, press one more time to become S, press one more time, a special character will come, and press one more time, then G will come. So typing a message or typing a text with this sort of phones is a real trouble. To overcome this trouble, there was an improvement in the arrangement of the keypads. I do not know how many of you will be remembering it. BlackBerry phones came out with that. They are called QWERTY keypads. Each and every alphabet had one button, not like 3 alphabets in one button. Now, what do you understand here? Is there any difference in the mechanism of operation in the mobile phones? Nothing. You press, a character will appear. But the only difference is that in this basic model, for a character you need to press twice or thrice. But in the new version of BlackBerry QWERTY model phones, one press is sufficient for every character. What is the difference here? Mechanism has not differed. The operating mechanism inside the phone has not differed, but only the arrangement of the keypads on the surface of the phone has changed. This arrangement, this version is also able to solve one problem of typing a message becoming easier. This sort of arrangements, this sort of innovations appearing on the surface of a product is eligible for protection under design rights. And you could see this is a Motorola company mobile phone. The moment I say you Motorola, so many aspects will come into your mind. They were very late men in the case of a mobile phone, then they became a giant, and now they are nowhere in the industry. So a single word Motorola is able to bring so many ideas about that company into your mind. The word Motorola is also an asset for the company, so that easy advertising is taking place for them. Just utter the word Motorola and you remember everything about it. So the word, that name Motorola, is also becoming eligible for protection under IP, and there comes the trademarks. And finally, every product that you buy is accompanied by a pamphlet. The pamphlet is nothing but one of writer telling you how better the product will work for you and how efficiently you can utilize it if you are handling it properly. You never read that one, that's a different aspect. But it is an innovative work done by the R&D people or the scientists of the particular company who has come out with this particular product. So that manual is also a creation of IP, and that goes into the protection of copyrights. So just a mobile phone I have shown you now. To complete this mobile phone, to entirely protect this mobile phone, its completeness, we needed 4 tools like patents, designs, trademarks, and copyrights in establishing a complete protection for this particular one product. Unlike the land or vehicle cases where one tool was sufficient to protect it, register it. Here, in some scenarios, one would be sufficient. In some scenarios, more than one would be sufficient. It is up to you, the innovators, who have to find out Is it one sufficient or more than one sufficient to protect my product in its integrity, completeness? Fine. Now we'll move on to patents. So patent is nothing but an agreement. When I say an agreement, two parties will come into picture. One, you, the innovator, the inventor. Second, we, the government of India. So this is an agreement between you, the innovator, and we, the government of India. When I say agreement, there will be some ifs and buts conditions, right? Yes. The ifs and buts conditions from your side is that when you want to file an application for protection of patent, we require only one thing from you, a complete report, right from the scrap till the end, whatever functionalities, whatever operations, whatever research you did on your particular work to come out with this particular innovative product. This is what we request. One report that should be complete in its aspect, right from the scrap till the end product, whatever methodologies, whatever steps, whatever aspects you perform should be detailed out. This is the only condition we expect from you. And in return, what do we provide to you? Protection for a period of 20 years. So you become the market player in that technology for 20 years. No one else can take advantage of your innovated work. If someone else is taking advantage of it, they are misusing it, if they are duplicating it, then there is a government of India, there is the court of law to take action against the infringers. And this is possible only if you get your work protected through IP. And in this 20 years of period, when you are the only market player, no competitors for you, you could commercialize your invented technology. You could make money out of it for your benefit, and you could also help the society at large in coming out with an improvised technology in your domain. So Government of India helps you out as well as the public, helps you in the aspect of giving protection to you, and for the public in coming out with newer technologies to society. So patent is nothing but an agreement between you and the Government of India for 20 years. And in this 20 years, you could make the maximum benefit from your research work. And finally, when I keep on saying patent, at the end of the day, what is actually given to your hand? This is what is given to your hand. It's a certificate. And if you could see here, the first line shows you a patent number, and there are some 6-digit numbers given to you. These 6-digit numbers is what we are all working for. At the end of the day, this is what is important to us. But below it, you see an application number. Now this has changed, this terminology has now changed. Now it's a 10-digit number we give you. Earlier it was based upon the jurisdiction, like Chennai or Mumbai or Kolkata, Delhi, depending upon it, we were giving you the nomenclatures. You could see here 1678 Kol MP 2012, meaning it was filed in 2012. It was filed in Kolkata Patent Office, and the number is 1679. But now this is not the nomenclature; it's a 10-digit number. And below that, you could see the date of filing, when it was filed. And below that, you could see the name, patentee. Here is what your name will appear. The person who has applied for the patent, his name will appear in the case of patentee. This is a German company, so company's name is appearing here in the certificate I'm showing you here. It's a German company. And below that, you could see 2 paragraphs, one at Hindi and one in English. If you read the English para, it states that it is hereby certified that a patent has been granted to the patentee. Patentee is you, your name will be there. Or an invention titled, and here that is mentioned in caps, mentions is the title of your invention. Whatever title you mention will be reproduced here. And after that, you could see at the last line, for a term of 20 years. So this patent is valid for a term of 20 years. And from which date is this 20 years starting? The 20 years starts from the date of your filing date, the date on which you come to the office and file an application. That date is the filing date. From that date, we accord you 20 years as protection period. And this is what at the end of the day you will be given. conversion of the 10-digit application number into a 6-digit patent number is what the entire history is about. Fine. Let's move on. So people generally ask me, sir, I am from the field of biotechnology, and I also do research here. Do my research work, do my innovative work in this field is also becoming eligible for protection under patent? Absolutely, yes. Any field of engineering, any field of science, you name any subdivisions in any of these two categories, and if there is any innovative work in that particular subdivided field, absolutely it becomes eligible for patent protection. All fields of engineering, all fields of science, Siddha, Ayurveda, any other allied sciences, every science, wherever innovation is taking place, they go under protection through patents. So do not worry that whether my field is, my innovations in this particular field, will it become eligible, will it not become eligible, no doubts. All fields of science and all fields of engineering, they become eligible for protection under patent if you come out with an innovative product. Fine. I need to share one case study here to show you how important this patent scenario is. Just sit back, relax, and hear the story. This happened somewhere in 1997-98 scenarios. It happened. You know, in Coimbatore, there is a research institute. It's called Tropical Botanical Garden Research Institute, shortly called as TBGRI. And there are scientists working there. The role of the scientists there is to analyze the naturally growing herbal plants and find out how those herbal plants are going to be of use to the mankind, society at large. And Dr. Pushpagandhan is the person who was working there. One fine day, what happened is that Dr. Pushpagandhan and this team of scientists, they decided to venture into the Western Ghats, that is very close to the Coimbatore area, and to extrapolate what are all the naturally occurring herbal plants available in the Western Ghats. But what Dr. Pushpagandhan thought is that Western Ghats is a new terrain for him. They may have the chance of getting lost in that particular new terrain. So what he thought is that let me take the help of the local people living in the Western Ghats. They are called the Kani tribes. The local people living in the Western Ghats are locally called Kani tribes. So he took their help. He asked them, some 4 or 5 people from the Kani tribes, to assist him in showing the way into the Western Ghats. So one fine day, 4 people from the Kani tribes and 5 people from TBGRI, Rotary Nayan, they started to climb the Western Ghats and excavate what is available into the Western Ghats. They climbed maybe 1 or 2 kilometers. They would have climbed the Western Ghats, and Dr. Pushpagandhan and this team of scientists, they felt very tired, and they sat at one place. When he turned back, he could not find any iota of tiredness or fatigueness in the face of the Kani tribes who were following them. So Pushpagandhan was shocked. How come all of us are climbing the mountain together and we have reached the same distance? Then we are so tired. How come you people are not tired? We could not see any iota of tiredness in your face. To which the Kani tribes, they looked around, they plucked some fruits in a nearby plant. It was something, a small black fruit, and they gave it to Dr. Pushpagandhan and his team of scientists to eat. When Pushpagandhan ate, he was immediately relieved out of tiredness and fatigueness. He was shocked. How come a small fruit from a plant is able to relieve me out of my tiredness and fatigueness? So he inquired the Kani tribes as to what is this particular plant is, to which they told that it is called Arokya Pachai, local name, so they call it as Arokya Pachai. And they told Dr. Pushpagandhan that we frequently eat these fruits to relieve ourselves from tiredness and fatigueness. And Pushpagandhan thought that this is the plant that I have to take to my research laboratory to make research and find out if this is going to be of use to the public at large. So he collected those plants, a bunch of those plants, came back to his research organization. And for 6 years, he did research on the particular plant. After 6 years of research, he came out with the output that 12 compounds in the particular plant, Aroke Pachai, is responsible for relieving this anti-stress and anti-fatigueness in the human body. He isolated those 12 compounds from the plant. After isolating them, he also found out that these 12 compounds are in enormous quantity, not in the fruit of the plant, but in the leaves of the plant. He also found out one more aspect, that if the leaves from two other plants were mixed in the ratio of 1:2:1, there was an abundant extraction of these 12 compounds. So this was his research output after 6 years. The 3 plants, if they are taken in the ratio of 1:2:1, and Aroke Pacha is in the ratio of 2. And the leaves of these 3 plants, if they are processed in one aspect, then you are able to get abundance quantity of those 12 compounds. Which 12 compounds are only responsible for relieving you out of the stress and fatigueness? This is what he has found out. And this research work of Dr. Pushpagandan was protected in India under patents, under 2 patents. You could see those 2 patents in the slide now. One was in 96, 959 MAS 96, the one application number. The other was in 88/Del/94 in Delhi. So these 2 applications was filed. These 2 were covering the entire aspects of 6 years research work held by Dr. Pushpagandan. And Pushpagandan thought, see, this is a very good research that I come out with. I should not stop this research with the just paper research work. This should go further. This should somehow be of help to the society at large. But Pushpagandan is working in a research institute. There he has got only limited powers. He could do research, but he could not take it to the next level of commercialization. So what Pushpagandan thought is that, okay, I should work out some other route of converting my research into a commercial product. And he found out Arya Vaidya Pharmacy. I know many of you would be aware of Arya Vaidya Pharmacy, working at in and around of Coimbatore region, who are very famous in coming out with traditional medicines. So Dr. Pushpagandan spoke with the Arya Vaidya Pharmacy people, and he explained to them about this research work. He also told them the benefit in the research that is going to be of use to society at large. And he also asked AVP if they are interested in coming out with a viable product out of his research work. And Arya Vaidya Pharmacy did the basic analysis, and they also found that it has got some commercial aspect in this. And an agreement was signed between Dr. Pushpagandan and Arya Vaidya Pharmacy. What's the agreement? That Dr. Pushpagandan will share the technical knowledge of his research with Arya Vaidya Pharmacy for a period of 7 years. Every year, Arya Vaidya Pharmacy is supposed to pay $50,000 as a lump sum amount to Dr. Pushpagandan and his team. Apart from this $50,000, 2% of royalty. That is, if a bottle, see, this product is named as Jeevani that I showed you in the first slide. This is the product. You could see the bottle there. Commercially, these 12 compounds, when extracted, they will come out in the form of a powder. And this powder is marketed in the name of Jeevani by Arya Vaidya Pharmacy. You could see AVP down. The name Jeevani, you could see AVP. It was marketed by Arya Vaidya Pharmacy. So this drug, this bottle, no, if it costs 100 rupees, then what is 2% royalty that has to be paid by Arya Vaidya Pharmacy to Dr. Pushpagandan? Is that 2 rupees per bottle? If the cost price is 100 rupees, then 2% royalty is 2 rupees. At the end of every financial year, they will do a auditing, see how many bottles of this Jeevani was sold, and based on it, a royalty amount was also paid by Arya Vaidya Pharmacy to Dr. Pushpagandan. So Pushpagandan, based on his 6 years of research work, he has come out with the drug Jeevani. This Jeevani was assigned to AVP. AVP was given the task of manufacturing the drug based on the knowledge shared by Dr. Pushpagandan, to which Pushpagandan received $50,000 lump sum amount every year for 7 years. Also 2% royalty on the total sales of the drug Jeevani. But there is one another person is also involved in coming out of this drug Jeevani. It's the Kani tribes, right? So they are also morally involved in coming out with this drug. So Dr. Pushpakandan thought is that he should share some of his profits with those Kani tribes also. So what he did is that 25% of this 50,000, that is $12,500 were transferred to the Kani people. He created a trust among the Kani people. The Kani trust was given this $12,500 every year. Apart from that, what is the source to manufacture this drug Jeevani? Is it not the leaves from the 3 plants? So who is going to provide the leaves of those 3 plants to Ayurveda pharmacy to have a continuous supply of the drug Jeevani? Dr. Pushpakandan can't go there and he can't cultivate the plants to supply as a raw material to AVP. So someone has to be assigned this task of providing continuous supply of the leaves of these 3 plants. So what Dr. Pushpakandan thought is that he selected 40 families of the Kani Trust. One member from each family was assigned the task of to cultivate the 3 plants. Every week, Ayurveda pharmacy will go there. They will collect the plants from the Kani people, and depending upon the harvest, those Kani people are also paid some amount by the Ayurveda pharmacy. But this plant, these 3 types of plants will grow only in the Western Ghats. At no other soil or no other climatic conditions, these plants grow. But the Western Ghat is a natural habitat. It's a forest area. The forest department will not allow you to grow any plants on a commercial basis in the Western Ghats. So Pushpakandan, what he did, he spoke with the forest department. He obtained permission for 1 hectare of land. In this 1 hectare, those 40 families of the Kani tribes were given equal share, and they were asked to cultivate these 3 plants on a commercial basis. So Pushpakandan's role was not stopped with research alone. He converted his research to the level of commercialization by making an agreement with AVP. And also he proceeded further and he spoke with the forest department, so that a piece of land in the Western Ghats was allotted to Kani tribes so that they could cultivate the plants on a commercial scale and give the source, these 3 plants, back to the Ayurveda pharmacy so that the continuous production of the drug Jeevani could take place. So my final moral of the story is that one research work by Dr. Pushpakandan, that one research work was protected by 2 patents, and those 2 patents have helped the livelihood of 3 sets of people: Dr. Pushpakandan and his team of scientists, Ayurveda pharmacy, and the Kani tribes. So now you could understand the importance of research, the importance of innovation, the importance of protection, and the final output is commercialization of our research work, and the final product helps you, the innovator, the researcher, as well as the public at large. Ayurveda pharmacy's Jeevani drug was a big success in the market. Mainly athletes who run for a short sprint and they have to continue immediately for the long sprint were in great demand for this particular drug. They wanted to immediately relieve themselves from tiredness and fatigueness. So this drug Jeevani was a big success in the market, and Ayurveda pharmacy was able to collect huge profits from this research work. And my final question to you is that if some medicine is a great success in the market, do you think there will not be any competitors for it? Yes, there will be competitors, but because of this Dr. Pushpakandan's protection of this research work through patents, he wiped out all the competitors in India. Unfortunately, protection is territorial. Dr. Pushpakandan protected his research work in India alone. He did not worry about other countries. Because of which, what happened is that you could see in this slide, NutriScience Innovation Limited. It's a New York-based herbal medicine company. They registered the name Jeevani at USPTO. The name Jeevani was coined by Dr. Pushpakandan and Ayurveda pharmacy together. But some other company, NutriScience Innovation Limited, has taken advantage of it. they have taken ownership of it at USPTO. Not only that, in the name Jeevani, you could see one another company, Great Earth Inc. It's another New York-based supplement and vitamin company. They developed a drink called Jeevani Jolt 1000, and they started marketing it in US, stating that this Jeevani Jolt 1000 also has got the property to relieve you out of stress and fatigueness immediately. Do you think this Jeevani Jolt 1000 is a genuine product? Absolutely not. How could I so surely tell you that? Because to come out with this drug, Jeevani, the source, the raw material is the leaves from the 3 plants. And those 3 plants will be grown only in the Western Ghats of around Coimbatore. This is a New York-based company. From where did they get this plant? Is it possible for them to grow these plants in New York? Which by itself says that this Jeevani Jolt 1000 is in no way related to the Jeevani product developed by R.A. Pharmacy and Dr. Pushpagandan. But Dr. Pushpagandan could not do anything over these 2 companies because his research work was protected only in India, not in US. Which by itself tells you that doing research, coming out with innovative product is not the end of the cycle. It is your duty, the researcher's duty, to take your research to the next level of protection, for which we, the government of India, are here through 8 different tools, right from patents, designs, trademarks, copyrights, geographical indications, pamphletory protection, trade secrets, and layout integrated circuit protection. There are 8 tools available with you. Choose one or more of which is going to be of close association to your research work. Protect them. Not only protection, the next level is commercialization. Had Dr. Pushpagandan not spoken to R.A. Pharmacy, this Jeevani would not at all have come into the market. It would have been just a paperwork lying idle, eaten by insects. So he thought the public should be benefited by my research work. So he went to the 3rd level of commercialization also. And now the athletes were immensely benefited by his research work. And we are all in one aspect, the people who are doing research, the people who are involved in innovations are all similar to Dr. Pushpagandan. We are on the 1st level down. We should move on to the next level of protection and to the 3rd level of commercialization. And you should commercially get benefited and also should benefit. Give some help to the society from where you have come from. These things are possible only if you protect your research work through patents. I hope now you could understand that how important this IP or intellectual property rights are to your research work. Fine, let's move on. Yes, every university you name, they generate 1/3 of their revenue from IP ventures. This is not any statement. If I just say this and show you the slide and move on, you will think, okay, this man can say anything and everything on the presentation. Who is going to verify it? This is not any mere statement. Go further, you could see these I have taken from IIT Bombay's website itself. There, they have gone to the 3rd level. Innovation is over, protection is over, now they are into commercialization. You could see there that Bombay is offering intellectual properties available as patents, know-hows for licensing. Licensing is what has taken place between Dr. Pushpagandan and R.A. Pharmacy. 7 years period, Pushpagandan gave it as a license agreement. His technical know-how was licensed to AVP only for 7 years. After 7 years, AVP cannot manufacture the drug Jeevani. If they manufacture, Dr. Pushpagandan will take legal action against AVP because that is what the license is. After 7 years, the technical know-how comes back to Dr. Pushpagandan itself. Like licensing, there are so many other rights involved with IP. One is manufacture. If I have come out with an innovative work, I could myself manufacture it by setting up an industry, and that I could myself sell it up instead of depending upon AVP or any other 3rd party. This is one right. Or if you think, okay, I do not have that big background to set up an industry and manufacture the drug, then I have to look around as to who are the role players or great players in this particular industry to whom I can license my technical know-how, like that has taken place between Pushpagandan and AVP. He licensed his technical know-how to AVP, and AVP manufactured it, they marketed it, they took the profit out of it, but the profit was shared based on an agreement back to the innovator. Or else, some people could think, see, I have come out with this, like what has happened with WhatsApp and Facebook. WhatsApp was developed by one set of people. At one stage, they thought that they could not handle it. They completely sold the WhatsApp to Facebook. Likewise, you could also completely sell your innovation to one another organization who are big enough, completely selling out. So there are several rights. You could manufacture, you could sell, you could license, you could give it as a complete selling out of the technology. There are so many rights available with IP. These rights you could enjoy as an innovator only if you protect your research work. Else it's not possible. And this is from IIT Bombay, showing that they have these many technologies in 35 technologies in energy and environment, 31 in healthcare, 31 in communication technology, and 41 in manufacturing, 47 in so many different technologies. They have researched, they have developed in so many technologies, and they have got protection for these many technologies. And now they are in the third level of commercializing all these technologies. Since IIT Bombay could not by themselves manufacture all these technologies, they are out for licensing agreement. And I will show you one other institute. This is Tamil Nadu Agricultural University, located at Coimbatore. And you could see here that the name of the scientist at Tamil Nadu Agricultural University and what innovation they have come out with. There are so many, 6, 7 innovations I could show you in this slide. And these innovations, while the professors, scientists at TNAU was also given out for licensing. This application number, this patent number 19834, it's a device to remove insect eggs from pulse seeds. This is given for minimum bid of 10,000. It's not the final bid. Whichever company is ready to commercialize this particular research work can come for the bidding. And the minimum bidding is 10,000. And whoever is going to offer the maximum bidding to them, this licensing agreement will take place. So I've shown you 2 institutes. One is IIT Bombay, the other is Tamil Nadu Agricultural University. So they are all now the third stage. They have innovated, they have protected, and now they are into commercialization through licensing. And I do expect Dr.M.G.R. University will one fine day will reach this particular level, and I will have the credit to show Tamil Nadu, M.G.R. University also as a slide in one another seminar of mine.
Sure, sir, sure. With your kind words, definitely we will reach it, sir.
That's what I wanted to hear from you, sir. It gives me more enthusiasm to proceed further.
Yes, sir. Yes, sir.
Fine, sir. With this bird's eye view of patent, I put an end to patent system. And I move on to the next system of designs. So I have shown you 2 pencils. One, the yellow one at the left. Can any one of you recognize to which brand this pencil belongs to? Do not break your mind. I too don't know.
Red one is Nataraj pencil, sir.
Absolutely, sir. The red one is Nataraj. How was it possible for you to identify it, sir? Is it not because of the color combinations?
Yes,
red,
sir, of course. Yes.
Yes, red and black color combinations and the pattern that is applied on the surface of the pencil. So the owner of the pencil that I've shown you at the left, if he decides, okay, why should I also not use the same color combinations, red and black, on my pencil? And if he introduces this pencil with this color combinations, what happens? Will Nataraj company be not at a loss? Yes, fine. And we, the public, will not be fooled. We will buy a low quality pencil thinking it to be of Nataraj pencil. Do you think these 2 scenarios good for the society and good for Nataraj? Absolutely not. So what should the Nataraj pencils do? They should protect. Protect what? Their color combinations on the surface of the pencil. This red and black line color combinations, this pattern. I could say this has to be a pattern on the surface of the pencil. Is patent system suitable for this protection of color combinations on the surface of the pencil? No. As I told you in the earlier example, arrangement of keypads on the surface of the mobile phone, BlackBerry's QWERTY type keypad. Is this not similar to one of that example? So if Nataraj pencils want to protect this color or line arrangements or color combinations on the surface of the pencil, then they have to choose the IP design rights. This is what we are going to see further in the next few slides. So an industrial design is going to protect patterns is going to protect two-dimensional features like patterns, lines, colors, and their combinations. And it also protects the three-dimensional features such as shape and the surface of the article. In the case of patent, if you are applying your research work for protection through patent, we check three aspects. If those three aspects are met, we grant you the patent. Those three aspects are novelty, non-obviousness, and industrial applicability. Let us not go into the details of all those stuff at this stage. Maybe we will get one other opportunity to discuss all those levels in detail. For a patent, we require three criteria as novelty, inventive step, or non-obviousness, and industrial applicability. But for an industrial design, we need new, original, and industrial reproducible. If your innovation on design is meeting these three criteria, then your application for design will be granted. What is this you see on the slide here? Is it not some soft drinks from Coca-Cola? But what is so special about it? I do not know how many of you are recognizing from the picture that you cannot easily open this Coke bottle. Just by turning its cap, you can't open it. This is designed in such a fashion that if two bottles of Coca-Cola, they have to be faced as shown in the picture. The cap, the top portion of this cap has got a specific pattern. If two bottles of different patterns are kept in this fashion shown in the picture, they click with one another. And upon clicking with one another, if you turn around, this bottle opens. What is this necessity for? This is the first question that arises in my mind. Why should I go with this design modification in the cap of a Coca-Cola bottle? Yes, to know this, you should know some background information also. You could have read in the newspapers that even school students at the US are taking out guns and shooting their friends. This was a common phenomena at one point of time in the US. And the US citizens were very concerned about it. How is that possible that a young kid is able to shoot his own friend with whom he has behaved, with whom he was acquainted with for many years? So it was really troubling them. So what Coca-Cola thought at that time is that the major lacunae there was that is the non-availability of interpersonal relationship. Had people been very closely known to each other, they would not have the courage to shoot his own friend. So what Coca-Cola thought is that I should come out with some innovation in my product which develops interrelationships among the citizens of US. Based on that vision in mind, Coke came with this bottle. Now I go to the vending machine, I drop in some dollars, I get one bottle of Coke out of the vending machine. Now I cannot open the Coke bottle because it is not so designed. What I have to do? I have to find one another person holding a similar bottle of Coke. I have to go to him, I have to say an hi to him, and I have to tell him that you hold a bottle of Coke and I hold a bottle of Coke, both of which could not be opened independently. Let us come together, let us put our bottles as shown in the figure, let us turn it, and let both of us get this bottle opened up. This is what is the intention behind them. If I go to a third person and if I say hi, will he be ready to respond to me? Absolutely not. He will think what ulterior motives I have in my mind. So he will not even respond back to me. He will move away. But when I go to him with this bottle of Coke in my hand, he will immediately recognize, okay, this person, stranger, has come to me with not any ulterior motives, but only to open the bottle. So I will not have any hesitation to talk to that stranger. That happened. So this bottle of Coke helped to create a friendship between citizens, unknown citizens of the US. What do you think about it? Is it not an innovation? Is it not a big innovation?
It's a very big innovation.
Absolutely. And if Coca-Cola is coming out with such innovations, what do you think about its market in the US? Will it not beat all other competitors like Pepsi or any other soft drink? Fine, it will absolutely beat other competitors. What if Pepsi also come out with a similar sort of cap in their own bottles? What could Coca-Cola do here? Because this is Coca-Cola's innovation. If Pepsi utilizes this innovation in their bottle, is there any remedy for Coca-Cola? Or will they keep silent about Pepsi utilizing their innovation? Absolutely not. So here comes the design registration. Coke immediately went to the US Patent Office and protected this design on the cap of the Coke bottle under design protection, so that no other companies can utilize this design on the caps of their bottles. Like what Natraj did to their pencils, that red and black pattern of colors applied on their pencils, no one else could copy it because that is protected by Natraj under design registration. Similarly, this is protected by Coke under design registration. So Coke had two goals achieved here. One, it brought a friendliness among the citizens of US. Second, because of this thinking about the well-being of the society, the Coke's reputation drastically improved in US, and people dumped Pepsi and bought Coca-Cola for this sake alone. And this was a limited edition version at US. Once that friendliness was sufficiently available among the US citizens, they stopped manufacturing this sort of bottles and they returned back to their original sort of bottles. But the design registration for this sort of bottles is still with the Coke. So now you could understand the difference between patent protection and design protection. I think you'll be able to understand between these two case studies. One I shown with Arya Pharmacy Jeevani drug. Now I've shown you the other case example with Coca-Cola. The first case was protection through patents. This is protection through designs. To some extent, I hope will be clear enough as to what sort of innovations goes into what variety of protections. You cannot take a two-wheeler or a four-wheeler to the sub-register office for registration, or you cannot take a piece of land to the for registration. So they all different scopes. Likewise, your patent and designs have different scopes. To explain you those different scopes, I've shown you these two examples. If you are clear about it,
very well understood, sir. Thank you.
Fine, then I'll move for this.
Yes, sir.
Yeah, this is, you could see in engineering products how the design come into picture. This is one tire, and the surface of the tire you could see various design impregnations. Maybe those design impregnations on the surface of the tire could help them out of not skidding. That could be a second aspect, benefit out of it. But the primary is that it has some design imprinted on the surface of it. So how could a design registration is judged? It's purely based upon your eyes. If a particular design is aesthetic to my eyes, then it becomes eligible for a design registration. It need not have any use there. Because of this design, it need not have any imbibed usage. Not at all necessary. If the design you put on a surface of any article is aesthetic to your eyes, then you could very well go for its registration protection design. It should be aesthetic. If it is aesthetic, go for protection. And if we check there, if it is new, original, and industrially reproducible, if your design meets these three criteria, we grant you the registration. As simple as that. this design registration is much simpler when compared to the procedural wise than patents. And those procedural aspects we will take up at later stages because we have very limited time now. Almost, I think, 75% of our time has gone, but still a lot of information to be shared. So that if time permits, we will look up later. And this design registrations have a major role in these categories, like textile and jewelry. Maximum, few years back, when I wanted to purchase a piece of any jewelry, what I would see is that which shop is giving me the gold for lowest price. That is what my criteria was. Depending upon the shops that was giving me the lowest price for the gold, I would go to that particular shop and purchase it. But later on, it became that the Gold Council come into picture. They made the price uniform. So wherever you go in India, the price of gold is made uniform. Now price has gone down. Then I looked at the quality. Is it ISO certified? Is it Hallmark certified? Is it having any gold seal, Gold Council seal on it, so that it has pure gold? Based on that quality, I decided the shop to which I'll go and purchase the jewelry. After which, this Gold Council also came out and they made the quality also standard. So many marks have come into picture, which was making it that whether it is BIS or Hallmark, whatever it might be, I could get an assurance over the quality. So quality also, that later stages faded away. Now, what is the URP for the shops to sell the jewels? It's now the design. In advertisements, I do not know how many of you would have noticed. There are jewelries for newborn babies. There are jewels for young girls going to college. There are antique jewels coming to picture now. And the USP for almost every jewelers now is the design. So as Mark Zizek told in this Time magazine, when companies are competing at equal price and quality, design is the only difference that matters. When design is making so much of impact, there should be some tool for them to protect it, right? So here comes the design registration. And every jeweler, every textile designers who are having this design as their role, as their core model, can protect their designs under design registration in IP. I told you 3 conditions should be new, original, and industrially reproducible. If these 3 conditions are met, you will be immediately given the design registration. New, what I mean by new is that we take up all, if you are going for a registration of a jewel, we take up all the jewels that is available in the print media, published media, and compare your application for jewel with all other available jewels in the market. If there is no resemblance of your design with the existing designs, then we ascertain your jewel design is new. Fine. For originality, how do we ascertain? See, we know about Qutub Minar. It's already existing there in Delhi. Now I come to the cigarette holder. The cigarette holder is designed in the shape of a Qutub Minar, miniature Qutub Minar. And I go for the protection of the cigarette holder, Qutub Minar shaped cigarette holder for design registration. Is it becoming eligible for design registration? Meeting this new and original criteria? Yes, it is meeting. You could ask me, sir, Qutub Minar is already available there in New Delhi. How could you grant a design registration to the cigarette holder of a Qutub Minar? What we adjudge you is that we compare all cigarette holders. Is any cigarette holder available in the print media in the shape of a Qutub Minar is what we see. We don't see the original Qutub Minar and we don't compare it with cigarette holder. You could understand now. There are classes in design registration. There are classes. Cigarette holder is coming in a particular class. We compare with all other objects of the particular cigarette holder class and we compare. And if no such cigarette holder of Qutub Minar shape is available, we adjudge this to be original. And industrial reproducible, okay, any product that you come out with is industrially reproducible. So it is meeting the 3. I could understand, I could feel that you could understand the 3 criteria of new, original, and industrial reproducible as to how we adjudge these 3 factors in your design application. Right. Yeah. In patent, I told you the duration of protection is for 20 years. It's fixed. You cannot extend the duration. 20 years is 20 years, fixed. But in the case of design registration, it is for 10 years. But if you want, you can extend it for another 5 more years by paying a nominal amount of fee. It's 10 plus, if you prefer, 5 more. 15 years is the total duration of protection in the case of a design registration. Do I have the liberty to proceed further, or is there any time limitation? Should I stop?
No, sir, you can proceed, sir. Very well proceed, sir.
Fine then, sir. Thank you. I'll move on first.
So I have a question, sir, now.
Yes, sir, please, sir.
What happened to after 20 years of the intellectual property rights, given patent rights, and then after this design protection of 15 years?
It will go into the public domain, sir.
Then anybody
You cannot own ownership.
Okay.
See, Dr. Pushpagandan, for his that Jeevani drug, Jeevani drug, it was all filed in 96.
Okay, sir.
So in 2006 and 2016, it got lapsed. Patent right, 2016 got lapsed.
Okay.
So after 2016, any company can manufacture the drug, Jeevani, and they can sell. No one can take action against them.
He cannot claim the right over it after 20 years.
After 20 years. After 20 years, it goes to the public domain.
Okay. Okay.
Any Tom, Dick, and Harry can manufacture drug. No one can take ownership out of it. The protection is only for 20 years.
So in that case, Nataraj pencil is, I think when I was in the school itself, they have.
Yes.
How can
Yes, 15 years over. 15 years over. But what happens is that they have this color combinations, no patterns.
Yes, sir. Pattern.
It's very well established in the minds of the public at large.
General public, yes, sir. Yes.
Yes, it's very well established.
Yes.
So no one other company will take advantage of a very well established design to their product. They will come out with their own innovative product.
Okay.
Innovative design registration. That's why no other pencil is taking up that sort of red and black combinations.
But if they want, they can have it. That's not an issue now. Because
but the morality comes into the picture, right?
Yes.
Morality, because that is still available in the market.
Yes, ethics is also there.
Ethics is also there.
Yeah.
Morality is there. You see, fair competition is there. Apart from IP, so many other aspects also there in business.
Okay, sir.
So predominantly other companies, they come out with their own design registrations.
Okay.
Their own uniqueness on their products.
They won't copy like this.
Usually they won't copy.
Yeah.
They take Nataraj as a source of inspiration.
Yes.
They don't literally copy.
Okay.
As Nataraj has come out with such a design and has got itself fixed in the minds of the people, other companies also think, why should I not take this as a role model, and I should come out with such sort of similar designs.
Okay.
That is how the company, they take it as a role model. They don't literally copy.
Okay, sir. Okay.
Fine, sir. With this, I put an end to design registration. I'll move on to the next slide. Trademarks. Trademarks. I should ask this one question. Ting, ting, ting. What do you remember? I just gave you one sound. Ting, ting, ting. Has anyone of you heard this sound earlier?
This is like a regal.
Britannia, sir.
Absolutely, it's Britannia's. See, at least the earlier two cases, I need a product. Jeevani, I needed a product. In the other case, I needed a pencil with so and so color combinations. But in this category, I did not have any product at all. Just a sound. The sound ting, ting, ting was able to bring you the name Britannia into your mind. So don't you think this sound is more important to any companies as compared to the other innovations?
Yes, of course, sir. Yes.
Then they should have some tool for their help to protect it.
Yes, absolutely.
There comes the trademarks, sir. So trademarks is for the protection of these many features. A smell, sound can be protected with a trademark. A brand, it's a Unilever is shown there. A signature, it's actually Tendulkar signature shown there. Tendulkar has opened a restaurant at Mumbai, and the name of the restaurant is his own signature. It's a trademark protection, eligible for trademark protection. Okay. Then a combination of a picture and word, you could see that Pepsi, it's a label, you call it as a label. This is eligible for trademark protection. And any name, Reynolds, is the name of a person going under protection.
So any of Godrej.
Godrej, yes. Bajaj.
Bajaj, yes.
They are all names of the person.
But that also comes under trademark protection, sir.
Absolutely.
Okay.
Under trademark protection. And you could see the word Google doesn't have any meaning at all. It's a coined word with no meaning.
Yes.
These words are eligible for protection. Letters A to Z, all 26 alphabetical letters are under protection. And A Dil Mange More, you could remember
Pepsi.
Yeah, Dil Mange More was utilized by Pepsi somewhere during the Kargil war scenario time. It was used. After which they did not make use of this caption at all.
Okay. Yeah.
But still, after 20 years, you could remember that A Dil Mange More, if you say, you could easily remember Pepsi. So you could understand the power of trademarks. This is called slogan. Slogans become eligible under trademark protection. Then the combination of letter and design, IBM, on which there is some design impregnated.
Okay.
And finally, Apple logo, just a picture. So
there is also time bound, sir. There's a time limitation for this also, trademarks.
I will come to that, sir. I will come to that. It's time bound, but as extendable to indefinite periods. That's a possibility is there. I will still come to that at later stage.
Yes, yes.
So there are 10 options with respect to trademarks, which are all becoming eligible for under trademark. So if I want to get a sound or a brand or a signature of protection to trademarks, is there any conditions? As we have seen now in patents, novelty, inventive step, industrial applicability. As we see in designs, new, original, industry reproducible. So what is the condition with the trademarks? The trademark condition is that the marks should be distinctive. This is the first condition. Second condition, it should not be deceptive. The third condition, it should not be identical or similar to any earlier marks in the same category. These are the three conditions being checked before awarding a trademark to any of your logos or labels or symbols, whatever you want to get it protected. Right. So three conditions in every IP right. Remember that this is a primary condition we check in all categories. If these conditions are met, we award you the rights. Fine. Amazon, you could see this. This is a trademark of Amazon. Should it have any meaning? This is one question that I frequently get from the people. Should my trademark convey any meaning? Not necessary. Like Google doesn't convey you any meaning. It's just a word. Likewise, not necessary. But if it conveys a meaning, it is well and good. In the Amazon trademark, what is the meaning being conveyed? You could see a smiley, yellow mark, yellow arrow, which is resembling a smiley.
Yes, sir.
It says that if you purchase any product in our Amazon store, you will be happy. This is one imbibed meaning that is being conveyed by this mark. The second meaning, we have all products right from A to Z in our store. Whatever you name, we have it here. So Amazon trademark is showing you two meanings. You become a happy customer upon purchasing from our site, and you could get A to Z any products in our site. So usually companies coin their trademarks with such imbibed meanings there, so that it easily gets fixed with the minds of the people. That is more important, right? So they do it. They put in creativity here. Because of such creativity is only this is becoming eligible for protection of IP under the category of trademarks. And with one case law, I will put an end to trademarks also. I don't know how many of you would be able to remember this sort of bidi. It's very famous during 1980s and 90s. Now it's not that popular enough. Mangalore Ganesh Bidis is a very famous product in the 1980s and 90s. And you know what is our interest here is that this is a label. You could see the picture of Lord Ganesha.
Yes, sir.
Below which the Mangalore Ganesh Bidis is written in English. And on one side it's at Kannada and the other side it's at Tamil. So this is the mark that was protected through trademarks under the category of label. Picture plus wording. Fine. So what are we going to learn from this one? Yes, beautiful story that I want to convey here. Again, sit back and relax, hear the story. So this was actually is a family business. The father and his two sons were manufacturing these BDs, and they were marketed under this label, trademarked label, So as long as the father was there was no issues. The family business was running well and good and was very popular around India. They were having enormous business there. But once their father expired, and this mark is like any other property, is transferable to the heir. If your father purchased a piece of land, and after your father, as a son, you become the legal heir of the land. Similarly, this mark is also a property, but intangible property. But still, it enjoys all the rights as like a land. So after when the father expired, both the sons, elder brother and younger brother, wanted to hold ownership of this particular trademark. But there was no possible amicable settlement happening between them. So what they thought is that they will approach the court of law to decide as to who will own the ownership of this trademark. So they went to the court and they filed there. What happened is that even the judge was also confused because both were the legal heirs of the father. So both have equal rights on this particular mark. He could not decide as to who should be given the ownership. So he was also, the judge like us was also confused as to how to give judgment in this case. What happened is that he thought, okay, I should find out some way. One fine day, he ascertained as to how much is the total worth of their property. That means the land, buildings, machineries, industry, movable vehicles, all those the tangible properties was ascertained, and it was around 15 lakhs. The total worth of the brothers was 15 lakhs of the land, building, movable, immovable properties, that together 15 lakhs. So that 15 or 16 lakhs, that was equally divided between these two brothers. No issues there. But the bone of contention here is this mark. So the judge decided, I should first know what is the valuation of this mark before giving my judgment. So what he did is that he left this mark on a public auction. Whoever is interested to own ownership of this label can participate in the public auction. And the highest bidder will be given the ownership of this mark, is what is the public auction told about. And you know, what was the highest bid that was offered for this Lord Ganesha picture with Mangalore Ganesh Bidis? Any guesses? When their total asset was only 15 to 16 lakhs.
No idea, sir.
This was worth 30 lakhs, sir.
Oh,
Just the label.
just the label alone.
Just the label alone. The highest bidder offered 30 lakhs in 1980s, 90s.
1980s, 90s is very big, huge amount, sir. 30 lakhs.
Extremely huge amount.
Yes.
So that is the power of trademark protection.
Trademark, of course. Yeah.
So now you will have the curiosity. What was the judgment then?
Yes, of course. I have.
The judgment was that whichever brother could give 30 lakhs to the other brother can own ownership of this mark.
Okay.
So that was the judgment in the Mangalore Ganesh Bidis.
Who gave how much to whom, sir? Elder or younger one?
I am not very sure about that one, sir.
Okay.
You could Google it out and you could find it yourself also, sir.
Sure. Okay, sir. Okay.
So what I wanted to convey here is that the power of a trademark.
Yes.
What is the worth of a trademark? We take things very light. But see, when their total asset was only 15 to 16 lakhs, just a label was able to fetch them 30 lakhs.
Yes. Double the amount of the.
We do research. We don't take it serious. We think, what sort of benefit is it going to provide me? Like that, we take it simple. And we put a full stop there and go further. That should not be the case. Even our simple research work might fetch big returns at later stages. We might not be knowing it.
Yes.
So my point here is that do not put a full stop after you perform a beautiful research.
Yes.
Take it to the next level of protection, and the third level of commercialization. Only when you go to the third level of commercialization, you will really understand what worth your research is. And commercialization without protection is like putting a piece of gold on the open street. Don't do it.
Yes, sir.
So when it comes to protection, IP plays the major role. IPR, intellectual property rights, play a major role. There are 8 tools. Decide the tool that is going to be of use to you and select that one, protect your innovation in its completeness. So next comes, what if someone is duplicating my registered mark? Criminal action will be taken upon them. They will be arrested, kept in jail. Apart from civil remedies, criminal actions will also be taken against them. But in the case of patents and designs, it's only civil remedies. No arrest, no jailings. But in the case of trademarks, copyrights, it's a criminal procedure. So a mark registered by someone under their name, if someone else is infringing upon it, they will be arrested. So that much of civil actions will be taken, criminal actions will be taken here. So protection, when you ask what is the duration, it's actually 10 years. After 10 years, you could extendable for another 10 years. After that, another 10 more years. So it goes on.
Okay, okay, sir.
Not like design 10 plus 5, it 10 plus 10.
Plus 10, almost 30
Yes.
years they are giving.
Yes, goes on. That is the duration of protection for a trademark. So I
Now
think
in Chennai, like we have a Talapagatti, Dindigul Talapagatti, the trademark name is there. And a lot of
yes,
people were misusing it, and that those original people, they filed a suit in the court and they got the, they won the case in their name.
absolutely, sir.
Does it come under this category, sir? Trademark
Absolutely,
category?
sir. Absolutely. Like the Ganesha BD, this is one other case law in trademarks. Dindigul Talapakatti is one. Dindigul Talapakattu is the other name.
Other name, yeah.
Katti and Katti doesn't make much of a difference in the
Okay.
in the case of an ordinary man.
Okay.
They think both to be one and the same.
Okay.
So, but the actual owners, the Dindigul, they had the turban tied around their head.
Yeah, of course.
Because of which it is called Dindigul Talapakattu.
Kattu.
So they filed an infringement suit against all other people. But their mark was not registered.
Oh.
Actually, it was not registered. But they showed evidence in the court of law that they have been working in this domain for so many years. And the common public has got very well established to this particular name of theirs. Every common public was able to know that this name is associated with that particular family.
Okay.
Though not registered, the popularity of the mark in the society helped them win the suit.
Oh.
Had they got registered it would not have been that much of difficult for them to win the suit.
Okay. Understood.
So my point here is protect it so that it will become easy for you.
Okay.
Finally, they won the suit, and all other people were prevented from making use of the name. Now you don't find any Talpa Katti, so many other related names you don't find in the market. It's only the Dindigul people.
Okay.
So power of trademarks is you yourself could identify one. I'm very happy about it, sir, that you brought up this example here.
Yeah, I'm asking the questions for the sake of others. They would have keeping their mics in mute position.
Absolutely. I realize it that you brought out this one here, so that otherwise I would not have elaborated upon this one.
Yes, sir.
Thank you, sir. Thank you for it. And if you permit me, I'll move further with the copyrights.
Sure, sir.
Thank you. Yeah. This is one which is very frequent, very predominant among every layman. As I told you, the diaries that you write, they become eligible for copyright.
Yes, sir.
The columns that women lay every day morning, if it is not copied, it's a copyright eligible.
Yes.
Even the selfies, the photographs that we take become a tool of an object of protection under copyright.
Okay.
So copyright is
even the movie stories, sir.
Absolutely. There are not. I'm not limiting it to here. Movies, a song comprising of a music, a lyric, a playback singer, a musician, a producer.
Okay.
So many people are involved in a song.
Yes.
So all are owning rights under that song through copyright. Broadcasting right now, IPL was broadcasted through Star Sports. Why other channels are not able to broadcast it? Copyright.
Copyright. Okay.
Broadcast right. It is called a part of copyright. Broadcasting right. It was awarded by BCCI to only Star Sports.
Okay.
So copyright is a big area. So it's a bundle of rights.
Okay.
Drawings will come there. Sculptures will come into this. It's a very wide area. So many. We call it as a bundle of rights in copyrights.
Okay.
But now I am going to focus only with respect to the literary work because we are from the educational background. We write books.
Yes.
We write papers.
Yes.
So in the copyright arena, I am going to focus only on the literary works, not to any other work.
Okay.
As I told, it's a bundle of rights. Other aspect is that an idea cannot be protected through copyright. The implementation of the idea is only can be protected through copyright.
Okay.
That's the point which you need to keep in your mind at this instant. Ideas can never be protected through copyright. How do you implement the idea? The way of implementation becomes eligible.
Okay.
This you could have very frequently seen in many of the books. The symbol C
See.
enclosed by a circle, some year and some name. This is the copyright. If some product, some work, literary work is protected through copyright, this is how it will be shown to the public. C enclosed shows it is copyrighted. Which year it was copyrighted is shown next. In this example, this was protected in the year 2012. Under whose name was it protected? Under Willow Misty Parks. Is the person was protected that work through copyright in the year 2012. And one more question people generally ask me, is it mandatory for me to go for a copyright protection? Unlike other rights like patents, designs, trademarks, copyright is default. Once the work is created, the copyright subsists on it. You need not specifically go and get a protection, get a registration. But then why should I take up all this effort in registration? Why? Because if at all tomorrow if someone else is infringing upon my particular work, then in the court of law, had it registered, it will be easy for me to prove it and get the damages collected. In the case of Talapakatti, where they had a huge difficulty in establishing their authenticity over the mark, had they got it registered, it would have been easy for them. Similarly, in copyright also, once you get it registered under your name, it will be very easy for the later stages in the court of law to prove your ownership on it.
Okay.
That's why we request you to get it registered so that you prevent all other difficulties in the later stages. Fine. There is one other shortcut also in registration. You write a book. You want to get it protected through copyright, but you don't want to follow this procedure of filing an application, following it up, all those stuff. You don't are not interested in it. I suggest you one simple procedure is that take the book, put it into an envelope, seal it.
Okay.
Write to address your name.
Okay, sir.
Your address.
Okay.
From address is also your name, your address.
Okay.
Speed post it or register post it.
Okay, sir.
It will come back to you
Okay.
with the seal from the post office.
Okay.
Do not open the seal.
Oh.
Keep it as such.
Okay.
So the seal mentioned by the post office on the wrapper is the date on which the registration.
Okay. Oh.
This is the simplest way of copyright
So
registration.
it is equivalent to getting a copyright, sir? Like
Yes, yes.
Uh-huh.
But the problem here is that suppose if someone else is infringing upon your work, you take it to the court of law. In front of the judge, you break the seal.
Okay.
The judge breaks the seal, takes it out, and establishes the validity, and he awards it to you. But once the seal is broken, the registration stops there.
Oh. Okay.
It's a one-time process. You cannot show it for the next time.
Okay. Okay.
But if you are registering it through copyright, it's for life.
Right.
Not for life. It's having its own term durations. Life of the author plus 60 years in the case of literary works.
Okay. Okay.
So this is for a huge period, copyright. If you are doing it the proper way. So three aspects. There are three ways. Not at all protecting it subsists, but difficult to prove your ownership on it.
Yes.
Through speed post, register post, you could do it, but one time.
One time. Yes.
But if you are protecting it through the Copyright Office, it's for your lifetime plus 60 years.
Oh, plus 60. Lifetime plus 60 years.
After the death of the author, you get 60 more years.
60 more years for his family.
For his family. Normally, because this is also like a land, like a vehicle, it passes on to the legal heir.
Okay, legal heir. Okay.
This copyright goes to the legal heirs. Now, give a simple example. Now, Sujata is no more. Author Sujata is no more.
Oh, yes, sir.
All his works are protected through copyright, and his family, his sons, are enjoying the copyright benefits.
Okay.
They are taking the royalties out of his work.
Okay, sir. Understood.
So, but if you're not getting it registered through copyright, it's difficult for your legal heirs to prove your ownership there.
Okay. So even like musician Ilayaraja also now filed a suit against SP Balasubramanian recently.
Absolutely, sir.
A year or two.
Absolutely. Yeah, that is not
asked
a
not
copyright.
to sing this song is in any of the musical programs, all those things.
Absolutely, sir. Because in the initial slides, I told you that in the case of a song, there are musicians are there, music director is there, the lyricist is there, the playback singer is there, and the producer is there. So in a song, there are 5-6 people who take ownership.
Okay.
Usually, what happens is that the producer pays the money to the musicians, to the music director, to the playback singer, the lyricist,
Yes, sir. Yes, sir.
and he owns the ownership of the song.
Okay.
But in some cases, what happens is that producer will not have any clear established documents to show who owns the ownership here in the song.
Okay.
Then all these 5 persons will try to take ownership of the song.
Oh.
There comes the issue.
Okay.
That was what happening between Ilayaraja and SPB, but now they have settled it out amicably.
Okay.
But this thing happen with the other music director, A.R. Rahman?
No.
Because he has a strong legal team.
Oh.
And the initial stage itself, the legal things are all sorted out.
Okay.
So there is no ambiguity here. Like that happened with Ilayaraja and SPB.
SPB. Okay.
He was shrewd enough to overcome all these legal ambiguities.
Okay. Everything has been documented and well established. Things
Yes,
will be there.
legally established.
Legally established. Okay.
Their copyright played a role.
Okay.
Fine, sir. I will move further.
Yes, sir.
And when I say the literary work, what are all the literary works that comes into the protection? Any books, even e-books that you write, they go under literary work and get protected under copyright.
Okay.
I write a book. After a few years, I come out with a new edition of it. I make many substantial changes in the book and come out with a new edition of it. That new edition is also protected under copyright. Novels, short stories, lyrics, poem, or a book of poems, all those stuff go under protection through copyright under literary work.
Okay.
Then the concept note. Sometimes judges pronounce their judgment, but for a layman it will be difficult to understand what the judgment is about. So usually what a third person will, some other lawyer will read through that particular judgment and he will give a concept note explaining in layman's language as to what the particular judgment is. That concept note will be given at the bottom end of the judgment itself. That concept note is eligible for a copyright protection.
Copyright protection. Okay.
Letters, what our first Prime Minister
Jawaharlal Nehru wrote to Indira Gandhi.
Absolutely. All those letters are eligible for protection. The lectures, sermons and speeches in writing, print and digital media. You give a lecture to your classroom.
Okay.
After the section, you come out and you write what you have lectured in a sheet of paper. That sheet of paper becomes eligible for copyright protection. Or else, now the voice is being, my lecture is being recorded.
Yes, sir.
This recorded lecture is copyright protected. Default.
Oh.
It's all coming under not this lecture. This recorded video doesn't come under literary work. It goes under broadcasting work.
Okay.
But it's a copyright protection.
Okay.
And further, the tables and compilation. You do research. You come out with
Yes, sir.
and you put some bar graphs and all. Nah?
Yeah.
They go under copyright protection and literary work. Judicial pronouncement, judgments.
So a lot of our research work involves like getting permission from the original author to use the tables or scales in our research works.
So if you yourself compile a table from the data, raw data, then that table becomes eligible for protection under copyright through literary work.
Okay.
Research thesis. We do research now for 3-4 years, then we come out with a research thesis. This is what we submit to the group of elite people.
Yes, sir.
Those research theses, research papers, dissertations, they are protected through copyrights and literary work. But in such cases, you need to get a no objection certificate from the college where you have done the research.
Oh, okay.
Then the questionnaires you prepare, question papers you give to the students. It's become eligible for protection.
Okay.
The brochures, catalogs, and pamphlets, whatever articles we purchase nowadays, a brochure or catalog pamphlet comes along with it. Those brochures, pamphlets, they are protected under literary work in copyrights. Then translation and adaptation. Say, sometimes some books are written in English, some novels are written in English.
Okay.
And a second person will translate that work in English into Tamil.
Okay.
So the translated version in the Tamil
Okay.
is given ownership to the second person who has translated it.
Okay. Okay.
But
Recently,
he got permission from the original author who has written in English.
okay.
Without his consent, he could not. The second person could not translate and get ownership.
No, recently I heard like author from Telugu, horror story writer, Yamamuri Virendranath. And his work has been translated in Tamil by Susila, some Tamil author.
Yes,
and he filed a case against this author, and he got a lump sum amount from this lady.
That's what, sir. You could translate, but the translation should be with the permission of the original. Sushila should have got permission from the Murari.
Yes, sir, yes.
If she had got the permission, this situation would not have been arisen.
Yes.
So you could translate any work to some other language, and you could own a copyright ownership on it. But for that, you should have got permission from the original owner.
Okay, sir. Nice.
And the computer programs and databases. So these many aspects can be protected through copyrights under literary work.
Okay.
Fine. With this case study, I'll put an end to my today's session. It's been long time. I will not drag you into a lunch session also. I'll put an end to here.
You're pleased to have
see the picture.
Laughing monkey.
Absolutely, sir. I do not know how many of you would have heard about this story.
No, I know the story, sir.
But still, I will elaborate here for the sake of the other participants.
Others would like to hear from your side.
Thank you for giving me the privilege, sir. I'll proceed. So actually, this is a macaque monkey living in the forest of Indonesia. It's a protected forest in Indonesia. The background behind the story is that John Slater is a person, he's a UK citizen. He wanted to take pictures of a monkey, very good pictures of monkey. So he packed his photograph, his cameras and all those stuff, and is left to Indonesia where these monkeys are in abundance. He tried to take photograph of the monkeys, but they are not good because monkeys are not like humans to immediately pose for the photograph. So he was not able to take any good photographs of the monkey. So what he did is that, okay, these monkeys are shy of me as well as my equipments. So let me first get myself acquainted with these monkeys. That is what he thought. So first day he went there, he allowed the monkeys to come near him. They came near him, they climbed over him. And in 2-3 days, he was a very good friend of all those monkeys. On the 4th day, he brought his equipments, his tripods, his cameras, all those stuff he brought. And he placed them amidst the monkeys. And he allowed those monkeys to investigate upon all those stuff also. After 5-6 days, those group of monkeys were very well acquainted with John Slater as well as his tools. So on the 7th day, what John Slater did is that he went there, put the tripod, he put the camera on the tripod, and he engineered all the settings as to how an auto photo should be taken, at what picture rate it has to be taken, what should be the aperture rate it has to go upon. Everything he engineered on the particular camera. He fixed that camera on the tripod and he left the place. So these monkeys who are already acquainted with the cameras, they came, they played with the cameras, and this picture was taken by this monkey. This is the first selfie of a monkey. And this was the best picture he could, John Slater could collect from the around 100 or 200 pictures he has taken at that time. All those 119 or 299 pictures are not that good enough. Apart from this single picture, it was very good enough as what he thought to be taken. Fine. He collected this picture, he went back. And he circulated this picture of the monkey to his friends. And you know, Wikimedia, it's a sister concern of Wikipedia.
Yeah.
They utilized this picture in their site. And John Slater, on looking into Wikimedia's utilization of this picture in their website, he asked Wikimedia to remove it, saying that he owns the copyright of this picture. And Wikimedia has no right to utilize this picture free of cost on their site. To which Wikimedia was not ready enough to agree. Why Wikimedia was not ready enough is that in the US, copyrights are assigned only to human, not to animals.
Animals, okay.
So Wikimedia stated that this picture is taken by the macaque monkey. So macaque monkey cannot own the copyright of this picture. So it is a free picture available in the industry. So what is the problem for us to utilize this picture in our site? At this juncture, PETA, you all heard about PETA.
People for ethical treatment of animals.
Ethical treatment of animals, yes. They came into the picture. They filed a suit against John Slater, stating that the ownership, the copyright ownership of this picture should be given to this macaque monkey. And PETA will act on behalf of this macaque monkey. And PETA will commercialize this picture. And the returns that is being obtained by the commercialization of this picture will be shared for the benefit of the monkeys, is what PETA told. And they will act on behalf of the monkeys. This is what the case they have filed against Slater. But again, in the US court, they were very clear that this picture taken, this selfie taken by the monkey should be legally owned by the monkey itself. But US doesn't allow copyrights for monkeys. So this cannot be assigned copyright to any of the person. In 2018, the judgment has come.
So anybody can use this photo?
Yes. That's why I have used it here.
Okay, sir.
So now it is being very clear that a photo taken by a monkey in US, this is for US alone, because copyright laws differs from country to country.
Okay.
So in US, animals cannot own rights, copyrights. So this is what has been decided by the US Court of Appeals in 2018.
Okay.
So a simple photograph. You could realize how much of legal issues has been created. So my point here is that we take so many photographs with our mobile phones. We take so many selfies with our mobile phones, but we do not know at what point of our life those photographs are going to implicate us in what aspect. So if some innovative work is created, if you feel that you have come out with some innovative work, do not hesitate in taking a protection of it. It might be of use to you at any point of your life. At that point, you should not feel sorry. Oh my God, I have left out at the right time. I should have taken protection again. You should not feel sorry at the later point of your life. My only objective of this session is to give you a bird's eye view of the IPR rights available with the Government of India, and how better you could utilize those IPRs for your benefit as well as for the benefit of the society at large. If that motto is achieved, I feel happy. My point is satisfied. Thank
100%
you.
achieved, sir. 100% achieved.
Thank you, sir. Thank you.
A lot of insights about the IPR and the patents and the copyrights, the design protection, all those things. It was really a wonderful session, brainstorming session. I hope all my faculties and students have gained a better knowledge about all these things after your session, sir.
Thank you, sir. Thank you, sir. But this is only a bird's eye view of the IPRs available. I have not gone into the intricacies of it. Possibly, I think I'll get some other time duration, because 1 hour is a very short duration to extract.
Definitely, we'll have the succession of this program, sir. This program should be followed with. We should take a separate session for patents alone and a separate session for copyrights, yes, all those things.
Thanks, sir.
That will be better, I suppose.
Sure, sir. Sure, sir. Sure, sir. I thank you for this opportunity that you have provided me to share some of the information to your colleagues about IPR. Thank you, sir.
So we should really thank you, sir, because we are nowhere near this knowledge. And today, after hearing your session, we have imbibed a lot of information, knowledge about all these things, and I will sure enough that all my staff members and as well as the upcoming students, both UG as well as PG, they will have a enthusiasm to either go for a patent or to copyright their research works, all these things. So we should really thank you on behalf of all my staff members, and especially Dr. Radhalakshmi, our Vice Principal. Without her initiation, this would not have been possible at all, inviting your good self to deliver a session on IPR. So on behalf of all of my staff members, I really thank yourself and Dr. Radhalakshmi, Vice Principal, for having interconnected you with our university and especially with Faculty of Physiotherapy to give this wonderful talk on IPR. Thank you very much, sir.
Thank you, sir. The thanks be mutual. Thank you,
Yes,
sir.
sir. Sure, sir. Sure, sir. So let us not stop with this. Our association should continue, and
Sure,
we'll,
sir.
in short, after a month or two, we'll meet again, sir, with
Sure, sir.
other topic like in related to IPR, sir.
Yes, sir.
If you are free
During which we will focus more on a particular right.
yes, sure, sir. Sure, sure.
Sure, sir. We'll do that.
Yes, sir. Over to Dharani.
Thank you, sir. It was really a great intellectual session. Thank you for that. Participants, the feedback link for the certificate have been posted in the chat box. Kindly fill it. Participants, if you have any queries, you can post it on the chat box.
Good afternoon, sir. It was really a wonderful session, sir. Thanks a lot for accepting my invitation and then presenting here. We have learned a lot of things from you, sir. Thank you, sir. I have a doubt. Actually, for the patent is taking nearly 8 months or nearly one year and 8 months. They have told. What about the designs and other copyright also?
Copyright usually takes you 6 months at the maximum.
6 months.
Because copyright, once you file, we publish it. We wait for a month or two. If any public is there opposing for awarding copyright to your work. If there is no opposition from the public, then they do the originality check they do. If it is original, then it will be awarded a copyright. Almost 6 to 8 months.
Okay.
Hello?
So we can get design patents and copyrights earlier than patents.
No, even patents you get earlier, but now the corona situation, we work only 50% strength. So many issues there. We did not expect this to happen. That's why a bit of delay happening here and there. But even patents, no, it's not going to take you that long period. But copyrights and designs shorter than compared to patents.
Okay, sir. Okay, sir.
Sir, I have a doubt, sir. I have a preliminary idea that I am not I have not completely with that idea, and I feel my colleagues or someone else who are very near to me can upload it as their idea. Can I protect? Can I protect it in any way, sir?
Absolutely, ma'am. Absolutely. See, in patent system, you have got one option called as a provisional application, which means that it's not mandatory for you to have completed the research. You could be midway. It could be midway. So now what you need to do is that whatever you have done till date, you just compile it.
Okay.
With that report, you could approach the patent office. There is a form called Form 1 and Form 2. If you are going to file on your individual name, the application fee is just 1,750.
Okay, sir.
Get the forms. In the forms, you need to, the Form 1, it's all clerical works. Your name, your address, from where you are from, what is the title of your invention, all those stuff should be asked for. Fill them up.
Okay.
Attach the report that you have prepared and file it as a provisional application.
Okay.
You have not completed your research, you are only midway. Still, you have got the option. Only to give you a safeguard over your co-researchers who might file the same application without your knowledge.
Yes, sir.
So this option is available with the patent system. It is called provisional application. But the condition here is that once you file a provisional application, you'll be given only 1 year time, 12 months time. Within the 12 months time, you need to complete your research and file the complete details. It's called a complete application. After provisional, you need to file a complete application. If you don't file in 1 year, then the provisional application will be deemed to be abandoned.
Okay.
So the time limit starts. 1 year is the time limit. You have to file within a year.
I have a doubt, sir.
Yes, sir.
So can the patent can be applied? It should be applied in a single man name, or it can be applied collectively, like 2 or 3 members.
You could, any number of persons can say there are 3 categories. You have got 3 categories of applicants.
Okay.
First, individuals. If you, Professor A, Professor B, Professor C, D, E, F, G, N number, no limitation. If all of you professors come together and file one application of patent, we take it as an individual filing, for which the fee is 1,750. Suppose you, as a Professor A, you go along with Dr.M.G.R. University. If you two come together and you file an application of patent, Then as an individual, we don't treat you as an individual. We treat you as an entity. Dr. M.G.R. University is coming to picture. So it is treated as an entity. The
Okay.
fees becomes 8 times higher.
Oh,
Or else you own a company, a startup company or a MSME company.
okay.
And the company's name could be filed. Because the company can have a board of directors, chairman, so many young people there.
Okay.
So the company's name, MSME company or startup company, this is special category to
Okay.
which could be filed. Fees is in between the individual and an entity.
Uh-huh.
It will be 4 times that of an individual's fee.
Okay.
So
Okay.
we have
Okay.
3 categories.
Oh, sure.
If
Okay.
it is a single person or a group of person, we put in one category.
Hmm.
If it is a industry, company, industry, institutional institutions, we put it in the
Entity.
third
It's
category.
an entity. Yes.
If
Organization.
it is MSME or startup company, you put it in the second category.
Okay.
These differentiations is only for the sake of fee collection, not for
Okay.
any other purpose.
Oh.
Procedures are one and the same for all 3 categories.
Okay. Okay. Okay.
Only for the category of fee collection, we are differentiated into 3.
Okay. Okay, sir. Any doubts from any faculty members or students? You can ask your doubts now, because we have to look into the time limit also. Any questions? I hope the session has given much knowledge about the intellectual property rights for all the staff members, teaching members, as well as the students community. Once again, I thank Mr. Thiyagaraja Gupta for having
Thank you, sir.
spared his valuable time and giving us a broad knowledge. Even though he said like a bird's eye view he has given today, but I would say like it's a broad knowledge what we gained today. And I hope this our relations will continue in future also, sir. Thank you very much for your valuable time and presentation, sir. Thank you.
Thank you, sir.
Thank
Thank
you,
you.
sir.
Thank you, sir. Now I request Dr. Deepti to express the vote of thanks.
Good afternoon, everyone. I take immense pleasure in delivering the vote of thanks this afternoon. I would like to thank our Founder Chancellor, Dr. A.C. Shanmugam, sir, for his consistent support and blessings on us. My heartfelt thanks to our Honorable President, Engineer A.C.S. Arun Kumar, sir, who has been encouraging and guiding us in all our educational developments. And I would thank our beloved Secretary, Thiru A. Ravikumar, sir, for his strong and consistent support. I thank our Vice Chancellor, Dr. Geeta Lakshmi, ma'am. And I am very much delighted to thank our speaker, Mr. D. Tyagaraja Gupta, MTech, Deputy Director, IPR Kolkata, for his wonderful rendition, sir. And I also extend my special thanks to our principal, Dr. C.V. Sendalnathan, sir, for his encouragement. And I deliver a special thanks to Dr. V. Rajalakshmi, ma'am, Vice Principal and the Organizing Secretary of this event. And I also thank Vice Principal, Dr. Veena, ma'am, for her support. And last but not the least, and I thank all the faculty members and the students for participating in this webinar. Thank you, one and all. Thank you, sir.
Thank you, Deepti. So thank you, sir. Let us
Thank you, sir.
wind the session today, sir. Thank you very much, sir.
Thank
We'll
you.
keep in touch. We'll keep in touch, sir. Thank you.
Absolutely, sir. Absolutely. It's my pleasure. Sure.
Yes, sir. Sure, sir. Thank you, sir. Our pleasure also, sir. Thank you. Thank you very much, sir.